of an armed robbery in which the gun was actually discharged, and there are critical pieces of evidence that I would want Investigator Kruger to be able to testify to in order to prove and meet my burden for the pretrial detention matter.
Mr. Cochran.
Your Honor, I understand the state's position. I would request that the continuance be denied and we proceed. My client has been sitting for, I believe it's 2 months, waiting for some kind of resolution as to whether or not he will be able to bond out. I understand the state was out when this was set. However, the officer knew he was on the pipeline for it. I think the state should have had contact information for him to have gotten him here today. But I will rely, whatever the court decides.
Well, and I understand this statute is still relatively new, and we don't have a lot of decisional authority regarding unusual circumstances. Here, the motions were continued essentially at the request of the defense because of the factual situation unrelated to the direct charges in this case.
Yes, sir.
Which is completely unanticipated by what the statute says regarding continuances.
Yes, sir.
And we all agreed that that was an extraordinary circumstances which suggested that the court should continue the pretrial detention motions, even though it wasn't directly authorized by either the statutory language where the state could request or the defense could request. So given that situation and that we've done this, I take this as the state's first request for continuance. And I'll continue it that limited period of time to next Wednesday. And if the state's witness is not available then, we'll dispose of the case one way or the other at that point in time. And so you can explain to your client why I'm saying all of this. I put my thoughts on the record. That way his rights are preserved if I happen to be wrong about this approach to the statute. But I'll take this as the state's first request for continuance based upon how we've approached it in the past and set the motion for 11/26 at 12:30.
Thank you, Judge.
Thank you, Your Honor. So we'll be back Wednesday. Okay. Sure.
Are we now to the arraignment docket?
Yes, Your Honor. Good afternoon, Your Honor. We have Mr. Tobias Lovejoy, case number 25 CF 2130. Your Honor, today I would acknowledge receipt of the information. We'd waive formal reading, enter a plea of not guilty. Does he have an offer to the record today, or?
I don't have an offer for the record or speaking to my victims, but I can say that he scores 18.3 months.
Your Honor, with that, I would like to leave this set for the 112.
So ordered.
If you bond out, call my office. If not, I'll see you at the jail.
Nichols.
this morning, Your Honor, or this afternoon, Your Honor, we have Mr. Ladrandro Nichols, Ladero, excuse me, 25 CF 2132. Your Honor, we would acknowledge receipt of information, waive formal reading, enter a plea of not guilty. I don't believe the state is prepared to make an offer today.
No, I did, I sent you.
Oh, you did?
Your Honor, that offer, given the possession of the weapon, would be an adjudication of guilt, 3 years in the Department of Corrections, that would be a mandatory minimum sentence, Your Honor.
So I'm gonna leave yourself for 112.
No supervision to follow?
No supervision of all, Your Honor.
Okay.
So I'm gonna set you for 112.
All right.
So I can live here.
112?
Well, it's because of the firearm. I don't have any evidence or anything yet. Yeah. They just filed information. All right. As soon as I get evidence, I'll come see you. What's tough, after Thanksgiving, we can I don't have the information, is all I have. There's no way to discuss it. I always ask. All right. Your Honor, I'd like to leave this set for 112 so I can review discovery.
So ordered.
Okay. I have no idea. I was talking about that. All right. Stephen Pinkins.
Judge, this is Mr. Stephen Pancoast in 25 CF 2136. Judge, I believe information has been filed. We'll enter a not guilty, waive formal reading. Speaking with the state attorney's office, they need to reach out to the alleged victim for restitution, since there's not an offer at this time. If we keep this on the 112 docket for pretrial conference, and if we get a resolution beforehand, I'll advance this on the docket, Your Honor.
And just for the court's awareness, the guideline score is a prison offer. However, we're trying to speak with the business that was at issue here and see if there's a potential probation offer that we can extend that would cover restitution, Your Honor.
So the guidelines is a DOC sentence?
That's correct, Your Honor.
And what is it?
Correspondence, there it is.
This one? Pancoast.
Almost there, Judge. I'm getting a lot of pinwheels. It would be 36.3 months in the Department of Corrections.
All right. We'll set it on 112.
Thank you, Judge.
All right.
Yep.
We have Rose Parrish.
Judge, this is Ms. Rose Parrish in 25 CF 2135. Yes, Your Honor, thank you. I first just want to address that, I believe on the clerk's site on November 5th, I just want to make sure I am still appointed to this. I believe it said defendant not indigent. What's that? Yep, or just clarifying with the judge now, just to make sure we're all on the same page.
Did you show the documentation that she was found not indigent only due to her application?
All right, let's take a look at that. Let's see what we got, okay? And your printer's not working, right? So which copy do I look at? Just saying. I got 4 copies. All right, it appears that the application is incomplete, probably because, as I tell people, it's a goofy government form, and unless you do this all the time, you wouldn't understand how to fill it out. Raise your right hand for me, please. You swear affirm testify truthfully in this matter under penalties of perjury.
Yes, sir.
Okay, you put your hand down. Are you employed? Do you have income from any source?
Excuse me?
Do you have income from any
No,
source?
no, sir.
No social security, no unemployment, no retirement, no pension? Okay. And no SSI, nothing?
No, I'm trying to get on disability now.
Okay. And you're currently in jail, so you haven't made a bond, right?
Right?
And do you have any cash in the bank?
No.
Okay. Do you own a car?
Excuse me?
Do you own a car?
No.
Do you own a house?
No.
Rocket ship? I'm just trying to add a little humor here.
No.
Okay.
No.
So do you have any other property that?
No, sir.
Okay. All right. Do you receive support from anyone else that's paid to you?
No. I do daily work sometimes.
How do you support yourself?
I
when
clean
you're not-
houses. I
Okay.
clean houses and do yard work and stuff.
Okay, and so that's just on a cash basis?
Yes, sir. Yes,
Okay.
sir.
And so last year, what would you say the total amount of income you had over the whole year was?
Well, I was in rehab
Okay.
last year, so, and I did work, but I paid them also.
Okay, so if you worked the whole year, about
I
how
didn't
much?
work the whole year. I probably got about 5,000. I only worked 2.5 months, 3 months in Keaton.
Okay, all right, so if we expand that to the whole period of time, do you say you maybe would make 15 to
Yeah.
18,000
Yes,
in
sir.
a year?
Yes, sir.
Okay, all right. After the examination of the defendant, the court finds that the defendant does qualify based upon the guidelines established by the federal government, and the court will appoint the public defender to represent the defendant under these circumstances.
Thank you, Judge. Judge, Ms. Parrish, we did receive the information. We'll be entering a not guilty, waive formal reading. Current offer, Your Honor, adjudication of guilt, 9 months in Okaloosa County Jail.
Credit for them, sir.
We'll get credit for that, yes.
All right,
And if we could set this for the 112 docket, then we'll speak privately in the jail.
Okay.
so ordered.
Thank you, Judge.
Thank you. All right, yeah, because I'm going to talk to you.
Yes, ma'am.
Thank you.
You're welcome.
Thank you.
Next will be Lacey Rashal with Mr. Gates.
Good afternoon, Judge.
Good afternoon, Mr. Gates.
If I could have just a minute, so.
Yes, sir.
Before the court is Lacey Rashal, case number 2025 CF 1160, and also case number 2020 CF 1820, which is a VOP, and case number 2022 CF 2748. At this time, we're prepared to withdraw our previously entered not guilty plea in case number 25 CF 1160 and enter a plea of no contest to that charge. In 2020 CF 1820 and 2022 CF 2748, we're prepared to enter an admission to those VOPs. If I could approach, I've got a plea and sentencing agreement in all three cases. The agreed upon sentence is that the sentencing would be left to the court's discretion, and we're going to ask for the December 18th court date. And Your Honor, one of the questions the court will have is whether or not we're going to ask for a PSI, and I need to discuss that with my client and let the court know whether that needs to be ordered or not.
Yeah, if we're going to order a PSI, I don't think it's reasonable to expect that by the 18th of December.
Okay.
Just candidly, with the intervening holiday and their workload, it's just not reasonable to expect it to be done in 30 days.
We would go ahead and proceed to sentencing without the PSI.
All right. And discussing that with your client, you feel, Mr. Gates, that you don't need the PSI to get the full information or to have the full information presented to the court necessary for the court to make a fully informed decision regarding the appropriate sentencing for the defendant?
That is correct, and we do intend to call witnesses at the sentence.
All right. All right. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do, Your Honor.
Okay, you can put your hand down. Now, you heard what Mr. Gates said, and you signed, you've got 3 different plea forms because we have 3 different cases, right?
Yes, Your Honor.
All right. And you've got your violation of probations, and you have your new charges. We're taking care of them today at the same time, but they're different things. You understand that?
Yes, Your Honor.
All right. Now, we'll start with your new charges. You understand by this plea arrangement on your new, well, first, how old are you?
41.
How much education do you have?
It's in college.
All right. You able to read and understand the plea forms?
Correct.
Did you do that before you signed them?
Yes, Your Honor.
All right. Do you understand by the plea on the new charges that you're pleading no contest to the charges?
Yes, Your Honor.
And what that says to me is that you believe if you went to trial, the state has the evidence necessary to prove your guilt to the jury, and you're not going to contest that.
Yes, Your Honor.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to present that evidence to the jury and prove to the jury your guilt?
Yes, Your Honor.
Now, as to your violations of probation, do you understand by these plea arrangements that you're admitting the violations?
Yes, Your Honor.
And by admitting the violations, what I understand you to say is, Judge, I violated my probation just the way those affidavits and reports said I did.
Yes, Your Honor.
And do you understand by making these pleas that you're waiving your right to a hearing where the state would have to prove that you violated your probation?
Yes, Your Honor.
Now, has Mr. Gates answered all your questions about these pleas and how they affect you?
Yes, Your Honor.
And are you satisfied with how Mr. Gates has represented you?
Yes, Your Honor.
Now, let's discuss what the nature of this plea is, which is really an open plea to the court. There's no agreement regarding your sentence. Do you understand that?
Yes, Your Honor.
All right. What does their score sheet show in this case, Mr. Gates?
Your Honor, the score sheet has not, it would be a global plea, so Mr. Snow hasn't prepared the score sheet, including the substantive charge in the 2025 case. She is and has been made aware that The maximum that the court could give in the two VOPs is 10 years in prison and 12, and a total of 12 with 2 years in county jail. And she's been advised that the maximum the court could give her in the 25 case, the substantive case, is 5 years in prison.
Does the state anticipate, with reworking the score sheet, that the defendant will score a minimum guideline sentence? All right, so it's presumed or believed that the defendant will score state prison based upon those charges in the plea.
Your Honor, full disclosure would lead us to advise the court that there, in the previous pleas and sentencing, there was a 3-year suspended sentence that the court will entertain.
So in addition to the minimum guidelines, there's a 3-year suspended sentence in the probation cases.
Yes, sir.
Okay. And the reason I'm asking all these questions is part of my job is to be certain that you're making a free and voluntary decision. The only way you can do that is if you know exactly what the facts and circumstances are. So it's presumed or believed that you'll be facing at least the 3-year sentence in state prison because that is the suspended sentence that you agreed to in the past. You will score a minimum guideline sentence on the new charge. I don't know how those two will overlap. The reason I say that is because by making the open plea, you're leaving it up to me to decide what sentence to impose. You understand that?
Yes, Your Honor.
No.
And Your Honor, we are going to be asking that the court continue to suspend that sentence, and we're going to give the court some alternatives.
And the reason that this is important is I try to use examples to explain why this is important. By leaving it up to me, if I'm just having a bad day, I can just sentence you to the maximum sentence. It would be legal, might not be the right thing to do, but it would be lawful for me just to, on sentencing day, just to sentence you to the maximum sentence based upon this plea you're entering. Now, I'm not saying that's what I will do, but you need to understand that you're leaving it completely up to me. Now, Mr. Gates has told me, and he's a zealous and good advocate, that he intends to present evidence to me and circumstances to me that would show that that's not what I should do. But you need to be aware that that would be a lawful sentence and that I can impose that. Do you understand that?
Yes, Your Honor.
All right. Does that change your willingness to enter into this plea arrangement? Okay.
No, sir.
All right. With that, Mr. Gates, do you believe the 18th will give you enough time to circle the wagons and get everything together that you need?
Yes, sir, I do.
All right. Now, with that, Mr. Sheldon, this is the plea you wish to offer the court, the open plea to the court, and with the information that's been provided.
Yes, Your Honor.
Okay. Now, Mr. Gates will still need your cooperation and any information he needs to be certain he is able to present whatever evidence he needs at the sentencing hearing to help me make a good and proper decision regarding your sentence in this case. Do you understand that, right?
Yes, Your Honor.
Okay. All right. And Mr. Snell, please provide that score sheet as soon as you possibly can to Mr. Gates so that he will also understand where he needs to be regarding that score sheet in his preparation for the sentencing, right?
Yes,
I understand that we have the suspended sentence, but he also needs that information, what your position is going to be regarding the score sheet so he can be adequately prepared for that sentencing, okay?
Okay, I was looking at the original score sheet from the 1820 case, and it was right at, it was 43.9. That's not including the VOPs and whatnot. So she's going to be a little over.
About how much time do you think you'll need on the 18th, Mr. Gates? you think?
Judge, an hour?
Okay. Because we're pretty packed now on the clerk on the 18th. So we just, pack a snack.
9 o'clock or 1:30?
It's going to be 2:30.
9 o'clock or 2:30, we'll be here.
2:30.
I think this one might be one of the hearings that kind of goes a little long. I think it's gonna take more than that.
Okay. All right. So I'll find the plea to be freely and voluntarily entered into. I'll accept the plea, open to the court, and we'll set it for sentencing on 12/18 at 2:30.
Thank you.
Judge.
Thank you. Mr. McKinney will be with us in just a second, okay?
Okay.
Do you see him, bailiff, Mr. McKinney? Why don't we put Ms. Taxter back, and when Mr. McKinney is available, we'll be with you in just a minute. Mr. Powell, are you ready with your client? Good afternoon.
Judge, I'm gonna have Ms. Fossil run down to the courtroom. She's going to come down. She'll be just a moment.
You want me to sit back down?
Yes, sir, I apologize.
Is he good?
All right, here comes Mr. McKinney.
I don't care whichever. I'll bring her.
Here comes Mr. McKinney.
And Judge, with Ms. Taxter, I'm going to need about 10 minutes with her in the attorney-client room to make sure that there are no questions on this plea.
Okay. All right. So he'll need her in the attorney-client room, please. All right. Mr. Cochran, anybody else you ready with?
Yes, Your Honor.
All right. Who is that?
I have Miss Anna Langenberg.
All right.
This is going to be a plea, Your Honor.
All right.
Yes, I will. Oh, 1 second, Your Honor. Can I get it?
So we had this set today for the motions to suppress. Are we withdrawing that and taking the plea?
We are, Your Honor. I need the state attorney to sign the agreement. I don't see him. Yes. I do have another matter I can handle until he gets here. Your Honor.
Who's walking in now, Mr. Cochran? And which case do we have with Madam Interpreter that I want to get, don't want to keep her holding? Well, let's get them up as soon as possible, okay? So we move her on to other cases.
All right, Your Honor. I'm
Go
ready
ahead,
to
Mr.
proceed.
Cochran.
Yes, Your Honor. This afternoon, we have Ms. Anna Langenberg, case number 25 CF1049. Your Honor, we have reached an agreement with the state where my client will plead no contest. For count 2, count 1 will be dismissed. That would be a withhold of adjudication and court cost prosecution and cost of defense. No other sanctions. If I may approach, Your Honor.
Granted. Raise your right hand, please. Do you swear affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you put your hand down. You heard what Mr. Cochran said. You signed the written plea form.
Yes, Your Honor.
You understand you're pleading no contest to the announced charge and waiving your right to a trial.
Yes, Your Honor.
In this case, adjudication will be withheld, and you'll have the cost to pay, which are, Madam Clerk? All right, so you'll have those costs to pay. How much time do you need to get those paid?
$6 months, Your Honor.
All right, 6 months to pay. Mr. Cochran answered all your questions about the plea and how it affects you?
Pardon?
Has he answered all your questions about the plea and how it affects you?
Yes, Your Honor.
And are you satisfied with how he's represented you?
Yes, Your Honor.
All right, the court will find the plea to be freely and voluntarily entered into and will accept the plea.
Next, Your Honor, Mr. James Wells.
Well, we're going to take the interpreter's case
Oh,
next so
sorry.
we can get the interpreter onto other territory.
So,
And then we'll take Ms. Basso and Mr. Powell after that.
okay.
And then we'll come.
Correct, 25 CF 2133.
Madam Interpreter, raise your right hand. Do you swear to interpret these proceedings truthfully, adding nothing and subtracting nothing?
I do.
Good afternoon.
Your Honor, we're going to acknowledge receipt of the information, enter not guilty, waive formal reading, request this be kept on the 112 docket. My client has my card and knows to make an appointment before that 112 date.
Does the state yet have an offer?
No, Your Honor, we are trying to get, I'm gonna say solid contact with the victim. There's also a translator, so we're having to go through language line, which makes it very hard to leave messages and things of that nature.
All right, we'll leave it on for 112. Stay in touch with your lawyer. Be back in court on January the 12th. Thank you. Do we need the interpreter for anything else?
None for Your Honor.
BD's office, Your Honor.
All right. Thank you. Good day. Mr. Powell, Ms. Basso.
Thank you.
Madam Clerk, this is Ballantine, 25 CF 1347.
Judge, this is a motion to modify the conditions of pretrial release. Mr. Valentine lives, if you turn on Racetrack Road by CBS, take the first right and another right, and everything's fine, but when they ran a GPS from pretrial, he's 883 feet, which is 117 feet from a daycare center. So he hadn't been able to go back to his house, which he lived there for 17 years. He couldn't even go by that day. He'd been living in a motel. And we filed a petition to modify the conditions of pretrial release to have a variance in the pretrial, and the pretrial services has no objection to the court granting this. And he's on pretrial release, not on probation. And the court has the authority to do it. And I just stepped it off from the wall there to the back door is 42 feet. It's 14 steps times 3, 42 feet. Double that's 84, and that's not counting from here to there. So that's more than 117 feet. I got it 126 feet. And that's all we're asking to do is modify where he can go back to his home. He hadn't been able to get his clothes. He hadn't been able to get anything out. And the court has the right to do that. And he's charged with some serious charges, but that's charges right now. And you know, he's added benefit. He's innocent until he's proven guilty. And we're only asking to modify that little bit of space, which is a distance from here from your bench to the door and back, which that exceeds it. And there's no prejudice to the state by not granting this motion. And that's all we have, Judge. It's, he was in the military 33 years, and he has no prior record.
GPS, right?
Yes.
State's position.
Your Honor, the state is obviously opposed to that due to the potential danger to the children in the community. The evidence supports a very strong interest in very young children. The neighbors have even been in contact with the state on this to let us know that they are in fear for their children. Your Honor, he's charged with 30 images, but the images so far recovered, and we're not even through all of his devices yet, are over 500,000 images. They are very young. They're infants and toddlers. There is actually an infant torture series in there that are so bad that HSI has told our experienced agents, do not open those files. This is what this individual is charged with, Your Honor. This is what he shows an interest in. These images go back for over 10 years. He's been collecting these. The searches are Bing image searches, which means you have to put in an image of child pornography in order to find an image of child pornography. This is the evidence that we have against Mr. Valentine. At this point, we understand he's innocent until proven guilty, but we do believe that the sum total of the evidence that we have shows that strong interest in children, and that really does make him a danger to the community. And so we are adamantly opposing a variance of that 1,000-foot rule. There is a daycare there. There's a reason for the rule, and we're asking the court to uphold that.
And Judge, if I may, pretrial service has been through all that. They have absolutely no objection to the court granting that small variance, which is a distance what we just talked about. And he, the state is right, he is innocent until he's proven guilty. And Judge, one other point, they measured that as the crow flies, straight through, not, if you went on the roads, it's a lot further than 1,000 feet. But if you go straight line to the daycare, which you can't go that way because there's houses and fences and everything else, but that's how they measure it with GPS.
So any objection to the court looking at a map to understand the actual layout of his residence versus where the daycare is, that's the question?
The state would have no objection to the court looking at the map. However, we believe the rule is pretty clear. It's 1,000 feet for a reason. It is, by as crow flies, is how they always measure those, Your Honor.
Any objection, Mr.
No,
Powell?
no, Your Honor, not at all.
So the defendant's address is the Placid Drive, right?
Correct. Yes, sir.
And to get there, he must go down Harbison. And the daycare is on Scranton? Is that where the daycare is?
All-Star Preschool and daycare
Yeah,
center.
that's Scranton. And there is no direct connection between Harbison and Scranton according to the map. Now, I understand that pretrial has the ability to vary this, but your client needs to know that if he is convicted of these charges, that even if the court varies this, I can't vary it if he's convicted by the statute. Right?
We understand, Judge.
And because, so looking at the map and the fact that it's on GPS and that there is no direct connection between the street which leads to his residence and the street where the daycare is located, which is Scranton, then the court will modify. However, the court is going to direct the pretrial, put a geofence on Scranton Street to be clear that if the defendant uses Scranton Street, that will be a violation of his pretrial release, for which the court will revoke his pretrial release, because the goal here is to accommodate them during pretrial, but at the same time to ensure the safety and security. So, do you understand? So I want the order to be clear that pretrial is to geofence Scranton Street, and actually I'm going to say Beach Drive, because Beach Drive is the street which goes to on the back side of the daycare. So he can turn down Harbison to get to his house, but he cannot use Beach Drive, he cannot use Scranton Street at all, and pretrial is to geofence those areas and prohibit him from being there.
You want us to draw an order on that, Judge?
Yes, sir, and before you submit it to me, I want you to pass it to Ms. Basso, and she needs to coordinate with pretrial to be certain that they can comply with the court's directions. If pretrial can't do that, and the reason I'm doing that, I'm looking at the chart, right, the map. And the record's not going to be clear, so I'm going to describe it as best I can from looking at. Okay. Beach Drive and Harbison come almost to a point on Racetrack Road. About 150 feet later is Scranton. In that little wedge is where the daycare is. So the court is concerned that based upon where those properties are, that we need to have a certainty that pretrial can observe his location, and that if there's any violation of this, that they will be able to tell us that if he uses those streets, it will be a violation of his pretrial release. All right?
I understand, Judge.
Understand? So
Understand.
pass that order by Ms. Basso. She'll collaborate with pretrial to be certain that, pretrial services, to be certain that they can execute the court's order.
And
Thank you,
Madam
Judge.
Rose, what date does the court show Mr. next Valentine's next court date?
Madam Clerk?
January 10th.
12th, I think, right? Yeah, 1/12 is the pretrial conference.
Thank you.
Okay? So, now, Ms. Ballantyne, I've done this a long time. You can't go back until you get that order, because I can't make up the circumstances. I've done this a long time. You go down there, and I don't know, he stops you because you got your tail light out, and you say, Judge Stone says it's okay for me to go back, and he's going to say, sure, I bet, where's the order, okay? So don't go back until Mr. Powell says, I have the order in my hand that says it's okay. Do you understand?
Yes, Your Honor.
Okay? All right. Thank you now.
Thank you, Judge. That's all I have.
Thank you. Good day. All right, who's next?
Judge, may I call Mr. James Wells?
Wells, please.
Mr. Wells is on the arraignment docket for 130 in 25 CF 2097. We would acknowledge the receipt of a 3-count information, waive its formal reading, and enter a plea of not guilty. I believe this is scheduled for the January 12th, 2026 court date at 9 a.m. We'd like it to keep it on that court date.
Is there an offer?
James Wells. Judge, I would anticipate there's likely not an offer at this point, as it's a CAC case.
That's correct. I can say that guidelines are 49.8 months with maximum 25 years.
That was 49.8
Yes,
points or months?
months.
All right. All right, we'll see you on January 12th. Stay in touch with your lawyer.
Yes, sir.
Tommy Lawson?
Lawson.
One moment, Your Honor, this is going to be a meeting. Just need to grab my pen.
He does, he will, it's just, I'm gonna talk to him some more, sit down with him, because it's the purpose of it. They shall be on this one though, I feel so much better, they hate if you sit in jail. Mine is, and always miss it.
Your Honor, we have Mr. Tommy Lawson, case number 25 CF 467 and 25 CF 468. Your Honor, we have reached an agreement where my client will admit the violation. We will modify probation for the remainder of his term to be drug offender probation with curfew from 9 PM to 6 AM, modifiable for work. He does work, what time did you say?
Oh, Your Honor, I work anywhere from 3:30 to 4 o'clock, starting off at the bingo halls here in Fort Walton Beach, so I clean those, so I would immediately, according to those time standards, I would be breaking,
Well, probation can modify that for
Okay.
you based upon your schedule.
yes, sir.
You just need to engage with them, and they'll tell you what you need to do to follow the rules.
Thank you, Your Honor.
So it would be a withhold, remainder of the probation would be drug offender probation with the curfew from 9 PM to 6 AM, modifiable.
I'm sorry, his probation term's April 2026.
Yes.
Yeah, which is why we said the remainder of probation is to be on drug offender probation.
Okay, he has enough time to finish everything?
That's up to him.
Because we'll have to violate it 90 days, which is
Why?
next month.
Why at 90 days?
Because if he doesn't have everything done, we have to notify the court 90 days prior to the end of his supervision. That is our,
But, Mr. Gomez, I'll just put it this way, as silly as this sounds, because that's what their regulations require.
Yeah, well, I'm good with what we have agreed upon.
Say again?
I'm good with what we have agreed upon.
I would ask, I mean, if probation is saying that there's a chance they're gonna violate him in 3 months, I would ask him if that comes, if there's,
No, not 3 months, next month.
no, next month.
Because
Then if
he
the only-
has to be close, he has to be able to complete within 90 days.
he owes $3,462.16 between court costs and I believe restitution.
Your Honor, I would proceed. I would ask that if a violation comes in a month, and the only thing is he hasn't finished these conditions, that a notice to appear is issued, if anything, and no warrant be issued if there's no new law or other technical violation, if it's only financials. But other than that, there's no other conditions that outstanding other than the restitution, which is a financial.
Why don't we just add 6 months, and then we'll put in an auto return provision upon payment of restitution?
Are you okay with that?
extend you for 12 months, auto term, and your restitution's paid.
More probation, more fines. I'm struggling as it is. I think I can probably try to pay off my probation as well as restitution. I'd rather do that than be on probation another 6 or 12 months. It's only fair. It's my first offense. I've never had any problems with it all.
Explain to him that what we're saying is if he does pay it, we're gonna auto early terminate
As
your
soon as you pay
probation.
it, you'll be off probation.
Correct, yes, that's what I'm hoping.
Yes, that's what we extend you for 6 more months. So
All
that
right.
there's a violation.
How about if we do this? We go ahead and restore him, and we make a provision that if the non-completion of the financial conditions will not be a basis for violation if there are no new law violations or other substantive violations. Can we do that?
So you're saying that should he not pay anything off, by the time he terms, he'll just be allowed to term and everything goes to a civil lien?
Yes.
He has made absolutely no payments.
Oh, I didn't know that. He's made zero.
0 payments.
Yeah, I'm not going to do that. He's made no progress, no financial payments at all?
I think the only thing he did was his treatment. I don't even know if he finished his community service. I'm
I-
showing
I
that's
have.
still open.
Yes, I've completed everything aside from that. As far as the payments, I just had to pay my child support attorney
Well, but-
$3,000, so I can pay this. I do
Well, we either
notice
have,
that.
I was trying to expedite this, but now that I understand those other circumstances, I'm not willing to do that. So either we got a deal or not, understanding that they're going to send the notice of violation in if he's not completed his financials. And now that I've heard that situation, I'm not willing to deviate from their norm.
I think we'll proceed with where we are. You're under with he has the understanding that he has very little time to get it done. I would ask, I think it's common that if the violation is financials, a warrant usually isn't issued.
Normally, if we have people that are making effort and attempts, yes, we would ask for a notice to appear. There's been no attempt. I'm not sure why you would reinstate for these few months. Why not send everything to a civil lien and allow him to just
And so
term?
what the law says is something like this. If the department is convinced that the person doesn't have the present ability, but notwithstanding their best efforts, then they can use their discretion to offer a notice to appear. What I hear the department saying is they're not in a position to make that finding. And so I can't intervene if that's their position. So if he wants to proceed, then he can proceed, but I'm based upon, once again, you hear me say this all the time, they're in the best position to know the defendant's not me.
He has expressed willingness to continue with the plea. He believes he'll be able to make the payment, or at least a substantial portion of it.
All right.
Within 30 days.
All right?
So, if I may, it would be, just for the record, one more time to make sure we're clear. Admit the violation, withhold, modify the remainder of his probation to drug offender probation with a curfew, cost prosecution, cost of defense, with the understanding that probation may violate him within 30 days if he has not paid restitution or made substantial movement towards the restitution. If I may approach, Your Honor, I have signed plea form.
Granted, raise your right hand. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do, Your Honor.
And all with that long circular argument here, you put your hand down. You understand that you're admitting the violation by this plea arrangement?
Yes, sir.
All right? And by doing that, you're telling me, yes, Judge, I violated my probation just the way the affidavit report says I did?
Correct, Your Honor.
And that you're waiving your right to a hearing where the state would have to prove your violation?
Correct, Your Honor.
Adjudication will continue to be withheld. You're going to be, the remainder of your probation is going to be on drug offender probation with a curfew, which can be modified to meet your work hours. and that you also understand that you're facing a pretty quick violation on your financials if you don't take some affirmative action.
Yes, sir, Your Honor. May I ask one question, please?
Of me or your lawyer?
Probably, I'm assuming of.
All right, we're clear?
Yes, Your Honor.
Okay. So now with all of that, Mr. Cochran has explained that to you, and he's answered all your questions.
Yes, sir.
Satisfied what he's done for you?
Yes, sir, Your Honor.
All right, find the plea to be freely and voluntarily entered into, I'll accept the plea.
Thank you, Your Honor.
Thank you.
And Your Honor, his score sheet is being printed off. We don't have any objections to it, and we'll provide it to the clerk as soon as it's down here.
Good luck.
Do you have any questions at all?
So this is the sign it and date it, right?
Judge, this is Linda Taxter before the court in 25 CF 906. We have reached an agreement with the state. The agreement calls for Ms. Taxter to enter a plea to a lesser included offense of aggravated assault with a deadly weapon, a third-degree felony. Madam Clerk, that should be 784-021-1A. And that is a plea to a withhold of adjudication, 60 months of state probation, special conditions of the supervision include no violent contact with Brenda Wilson, who is Ms. Taxter's sister, present in the courtroom. Reside at the Bridgeway Apartments until further order of the court. She has been approved by the Bridgeway Apartments, and they are available to receive her on Monday. So she would be released from the Okaloosa County Jail at 0800 on Monday, the 24th, 11/24/25, to be released. And then she will need to report to probation and then report to the Bridgeway Apartments. She must complete a mental health evaluation and any recommended treatment, complete a substance abuse evaluation and any recommended treatment, complete 2 AA meetings per week, have no drugs without prescription, take all medications as prescribed, have no alcohol, be subject to random breath testing, random urinalysis. She must possess no firearms, maintain gainful employment or submit 2 job applications per week, and complete an anger management course. Court costs are in the amount of $867. There's a $150 cost of defense. We are requesting that the court waive the cost of supervision, given that at the moment she is going to be on fixed income. No objections to the score sheet, which reflects 36 points. May I approach with plea agreement signed by myself, my client, and state?
Granted. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
Do you put your hand down? You heard what Mr. McKinney said on your behalf and signed the written plea form.
Yes, sir.
All right. How old are you?
69.
And how much education do you have?
12 years.
Are you able to read and understand the plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And is what you read in the form what Mr. McKinney just announced to
Yes,
me? Do you understand by this plea arrangement that you're pleading no contest to the announced charge, which is a lesser included offense?
Yes, sir.
And by pleading that way, I understand you to tell me you believe that the state has the evidence necessary to convince the jury of your guilt, and you do not intend to contest that.
I do.
Do you understand by making this plea, you're waiving your right to a trial by jury where the state would have to produce that evidence and convince the jury beyond a reasonable doubt of your guilt?
Yes.
And in this case, adjudication will be withheld, and you will be on
5 years probation.
5 years probation with the special conditions. And some of the principal conditions are the no violent contact with the named person. And I like to explain in the context of probation what no violent contact means. It doesn't mean just no physical fighting. It means no conduct by you which would cause a reasonable person to fear that actual violence was imminent. And I generally point at these folks in the green uniform as my reasonable person, because they're generally who shows up, right? And if they believe that by your conduct, actual violence is imminent, then that would be considered to be violent contact. And violent contact is a specific provision of this plea arrangement because of the operative facts of your plea. Do you understand that?
Yes, sir.
Okay. And the other condition is that you will reside at the Bridgeway Apartments, and that is a material condition of your probation as well. Do you understand?
Yes, sir.
As well as the evaluation and recommended treatment, and both on the mental health and also the substance abuse, and also the trying to categorize these, Mr. McKinney, this would also be the prescription maintenance with your physicians or other treaters as well. And gainful employment?
That was a request from the state. So that is part of the agreement.
All right. All right. And the anger management course, which will be, the probation will help you get enrolled in that and help you complete those conditions.
Okay.
All right. Has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir, he did.
Okay. And have you been satisfied with how Mr. McKinney has represented you in this case? Now, the only question I have is have we arranged for the transport necessary on Monday?
Yes, Judge. Her family is present in the courtroom. They are going to assist with making sure she's got everything that she needs upon her release from jail. She does have a driver's license and a vehicle of her own. They are making sure that that's going to be where it needs to be so that she has access to it. And I believe that they're also going to assist in making sure that she makes it to probation and to the Bridgeway Apartments on Monday.
All right. And so you would need to also report to probation, and they're going to give you instructions on how to do that.
Okay.
Do you have any questions?
No, sir.
Okay. All right. So if you do, you need to reach out to Mr. McKinney, and he'll assist you. And also the probation office will explain and help you in any of these conditions as well.
Okay.
All right.
Thank you, Your Honor.
Thank you. The court will find the plea to be freely and voluntarily entered into and will accept the plea. Thank you. Gotcha.
Good afternoon, Judge.
Good afternoon.
Excuse me, if I may call a couple that are in the courtroom.
Yes.
Mr. David Polkowski, who's present and approaching, 25 CF 2134.
Yes.
Your Honor, we acknowledge receipt of the information, enter not guilty, waive formal reading, request this be kept on the 112 pretrial docket, and the current offer is a 6-month county jail sentence, adjudication of guilt, Your Honor.
All right. We'll leave it on for 112.
112 is our next court date. Call, make that appointment.
Okay, well, thank you.
You're welcome. Next judge, last name Shoup, S-H-L-U-P, first name Heaven. She's present and approaching, 25 CF 2096. Your Honor. Judge, acknowledge receive the information. We'll enter a not guilty today, waive formal reading. Request this be kept on that January 12th pretrial docket. Speaking with Mr. Snell, this is a potential PTI diversion program, so we'll be discussing that.
All right, very good. Beyond 112, stay in touch with your lawyer, and he'll give you instructions regarding your future appearances if the PTI is not complete.
Yes, sir.
All right, thank you.
Good to go.
Information has been filed.
Yes, yes. Next, Judge, last name is St. Jean, first name Curvins, who's present and approaching, and that's 25 CF 2107, last name St. Jean. Your Honor, we acknowledge receipt of the information, enter not guilty, waive formal reading. Speaking with Mr. Snell, we're gonna talk some resolution to this, possibly hopefully help you get a license.
Okay, good, because that's the principal issue involved, right?
Sir.
And so I'll help in any way I can, as long as the state is agreeable to that, okay? That's the goal. All right, all right. So leave it on for 112, stay in touch with Mr. Koch, and he'll give you further instructions. All right, thank you.
Next court date, call, make that appointment. Yeah, you're welcome. Absolutely, absolutely.
Granted.
Judge, that's the remainder of my cases. Well, I guess
I
we
show Melvin Saavedra Vasquez. (25 CF 2093). Tables are turned. Generally, you're the one who surprises me with a case that's not on the docket.
Judge, I'm looking right now at 25 CF
Let me see if I'll find it on Jesse. It's 3-count obscene communications times 2 and 2A device times 1. Is that your case, Ms. Barrickman?
Yes, Your Honor, it is.
Do you have it on your docket?
I do.
Okay. 2 against 1 there, Mr. Koch.
I see that, Your Honor.
I'm just trying to add a little humor for our struggles.
I got you. See, information has been filed. I'm just seeing if he was served.
It does say ice hold on his paperwork. So I don't know if we have any information. Is he in jail?
I didn't have all my transport with us, I don't know if she's in jail. I can ask her when she, what was the name?
It's Melvin, last name Savedra, second last name Vasquez, Vasquez. And the first appearance paperwork says ice hold. And then I also show for you Destiny Sanders. Mr. Koch.
Yes, I was just checking out Miss Sanders' case. I see she was released from the jail on the 2nd of November. I was trying to see if she was properly served to be here now.
So notice went to her bondsman. But I see the bond has an 11/25 appearance date.
And then it was November 12th.
Who has court on 11/25?
That person's not showing in Gary Arnold.
I don't see who has court on 11/25.
All right, well, what about, state, what about Ms. Sanders with the conflict and the bond and the notice?
We're not sure why she's not here.
She had notice to appear.
She got, the bond says the 25th, and the clerk's notice went out for today, so she has two conflicting notices.
I just set it for the next arraignment.
When is that, Madam Clerk?
Oh,
12/11. All right, and so what do we want to do with Melvin Saavedra Vasquez?
We'd ask for a habeas in this case.
Correct.
All right.
Okay. Your Honor, may I